Hello, this is Matt on the Moon Lambo channel. We've seen yet another stunning capitulation on the part of the SEC. They are throwing in the towel. Take a look at this headline from Cointelegraph. SEC backs down on claiming Solana, Cardano, Matic, other tokens are securities in Binance suit. Folks, it's so embarrassing for the SEC. Let's be real. They don't have human emotions. These are winged creatures, spawns of Satan over at the SEC, so they don't actually feel things. I get that. They're just a bunch of asshat pricks. They should feel embarrassed because they go into court making just absolutely audacious, completely unreasonable claims stating that the token itself is the security. And then they get vibes like, this might not play out so well for us in a particular case. And then like, no, just kidding. We're not gonna claim that these specific cryptocurrencies themselves, just for the sake of them existing, are securities. What in the ever-loving hell? This is the crap that we've been putting up with for years. They made these ridiculous claims about XRP. XRP itself is a security. And then you ask them, are you claiming XRP is a security? No, we're not saying that. But then you look at their arguments and all of their arguments actually argue that. It's just so two-faced. So I'm going to share with you the update on this because it's kind of funny and in a way just delightful to see this because the SEC, they know they're backed into a corner. Like, they're on the wrong side of history. But I have commentary for you from Ripple CEO Brad Garlinghouse, Ripple Chief Legal Officer Stuart Alderati, Attorney John Deaton, as well as Attorney Jake Chervinsky, who is very well known in the world of crypto. But before going any further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so what have these asshat pricks been up to recently? Let's jump right on in. The United States Securities and Exchange Commission is no longer asking a court to decide and deem the tokens named in its lawsuit against crypto exchange Binance as securities. On July 30th, the SEC filed a response to the court's minute order on July 9th, 2024. In the filing, the SEC wrote that it seeks to amend its complaint regarding the third-party crypto asset securities defined in its opposition to Binance's motion to dismiss. Okay, I'll just note here, and because that's a quote, third-party crypto asset securities. That's not a thing that exists. The SEC just started using that terminology within the last couple years, roughly. They just call it the thing that doesn't exist. And then they have to amend the complaint. So look at this. Here's what they actually wrote here. This is a screen grab from it. The SEC informed defendants that it intends to seek leave to amend its complaint, including with respect to the third-party crypto asset securities as defined in the SEC's omnibus opposition to defendants' motion to dismiss, obviating the need for the court to issue a ruling as to the sufficiency of the allegations as to those tokens at this time. The parties met and conferred and have agreed to the following proposed schedule for a briefing on a motion to amend and related pleadings. So there we go. They made these ridiculous broad claims the tokens themselves are securities. Then they kind of got vibes it's probably not going to play well in this particular court. And then they're like, just kidding, we don't need to argue that anymore. Well, then what were you doing? Like, are you kidding me? Piece continues. According to the SEC, this removes the need to issue a ruling as to the sufficiency of the allegations as to those tokens at this time. This means the government agency no longer asks the court to decide whether the affected tokens are securities. In its suit against Binance, the SEC claims several tokens were securities, and they go on to list them on your screen. I'm not going to read them, but they're on your screen if you want to take a look. These tokens are just part of a bigger list of tokens that the SEC believes to be securities. In June 2023, the SEC claimed at least 68 tokens were securities, affecting more than $100 billion worth of cryptocurrencies in the market. And so what's being said? Well, here's John Deaton's crypto law organization. They shared this story and wrote the following. So much for Judge Torres being wrong. Now even Gary Gensler is scrambling to back edit his BS. The token itself is not a security, but how it is packaged and sold might be. That's the law to which Gensler shows no faithful allegiance. It's time, hashtag Gensler's gotta go. Spot on. And remember that there are people like, for instance, Fox Business journalist Charles Gasparino. He was saying Torah's got this thing wrong. Well, the courts aren't thinking that's the case. The more time passes, the more you see that there's actually that the Torah's decisions is actually being cited in other cases. So, I mean, this is going to stand. It's very clear we're on the right side of history. To me, that couldn't be more obvious. And as far as the token itself, being packaged and sold, anything can be packaged and sold as a security. In fact, Bitcoin was. There was a 2013 Bitcoin court case where Bitcoin, the court found, was packaged and sold as a security. It didn't make Bitcoin itself a security. You can look it up. I think it was, I could have the court case name wrong because it's been a while since I thought about this. It might be SEC v. Shaver. I apologize if I'm mistaken. SHAVER. I think that's it. But it was a fraud case, and then they found that there were some illegal securities transactions with Bitcoin. Same deal, because it was packaged as such, but it didn't make Bitcoin a security, just like XRP wasn't made a security, just because of the nature of it existing. Like there's no way, nothing that Ripple or anyone else does would make XRP itself a security. Here's a post from Brad Garlinghouse. He said, "More evidence of SEC hypocrisy. Chair Gensler testifies the rules are clear, yet his SEC can't figure them out and applies them haphazardly, festering more industry confusion. A political agenda and/or bad faith litigation tactics. Definitely not a faithful allegiance to the law." And he put that in quotes because, as you'll recall, Magistrate Judge Sarah Knepper in the SEC v. Ripple case noted that the SEC was definitely lacking a, quote, faithful allegiance to the law, end quote. And they certainly were. And that's the most stunning reprieve I've ever seen. I mean, maybe there's worse. I'm not an attorney, but it's certainly the worst I ever saw in the SEC v. Ripple case. But I can't think of anything worse sounding than that in a non-fraud case. I've never seen it before. The judge went out of her way to say, you're not being faithful to the law. That was a big deal. And so here, Brad Garlinghouse knocking it out of the park. The SEC being very haphazard. These things are securities. No, just kidding. No, we're saying they're not security. We're not going to say they're not securities, but we're going to stop arguing that they are securities. Just for this case, though. Just for this one, right? And by the way, it doesn't mean that they're giving this up in other cases, but that's what they're doing here. So that was reposted by Ripple CLO Stuart Alderati, and he wrote, "When a judge signals BS on the SEC's claim that 10 tokens on Binance are securities, the SEC says, never mind. But these tokens are left out to dry in the Coinbase lawsuit. This isn't how to regulate." Right. And so they have different approaches for these different cases. It's so inconsistent. It's so disingenuous. If I'm a judge, I could see this. And the good news is the judges in various cases, broadly speaking, they have seen just how disingenuous these asshat pricks over at the SEC are behaving. Here's a post from attorney John Deaton. "This is further evidence that Gary Gensler should resign immediately. In the Ripple case, I was forced to sue the SEC and file a motion to intervene in order to protect retail investors. In that case, I argued Gensler and the SEC were violating 76 years of established case law. In other words, the claims were not supported by law. In return, the SEC attacked me personally and misled the court. The judge, a lifelong Democrat appointed by President Obama, ultimately agreed with me and my 75,000 clients. Now, after causing billions of dollars in damages to retail investors, Gensler's SEC is backing off some of its absurd claims. Gensler, at the direction of Senator Elizabeth Warren, lied under oath on more than one occasion, as Brad Garlinghouse points out. If the rules were so clear, as stated by Gensler, why are his lawyers backing off those very clear rules? Well, that's a good question. It's because they're not acting in good faith, obviously, and of course, Attorney Deaton well knows that. That's the reason they're making crap up. It's whatever is in their best interest. There's this post from attorney Jake Chervinsky. He said, "There is no reason to think the SEC has decided Solana is a non-security. That they don't want to do discovery on a dozen tokens in the Binance case appears to be a litigation tactic, not a change in policy. Note the SEC still calls these tokens securities in other exchange cases." Yeah, and so that's in line with what Stuart Alderati said. But I thought I'd highlight that because it really puts a spotlight on the degree to which the SEC is disingenuous. They're arguing different things in different cases about the same tokens. These people are disgusting and despicable. At least XRP's through the gate. We got our legal clarity, and we in a damn bull run, son. So we gonna get ours. But wow, what a journey this has been. Isn't this freaking crazy? How is this real life? These are adults by age, though not behavior. Barely human, right? I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Mambo.